arose.
Yes, Mr. Watkin.
Well, before the short adjournment, I was just about to take your lordships very briefly through Ireland and Britain. I appreciate that your lordships are extremely familiar with this authority, so I wish to be quick. Nevertheless, my lord, I would like to emphasise a few paragraphs which you weren't necessarily taken to before lunch. I mean no criticism by that. It's behind tab 9.
Yes.
And if we begin at paragraph 15, which is the familiar now judgment of Lord Neuberger.
Yes.
After summarising the law of contractual construction in one paragraph, 15, he says at 16 that he wishes to emphasise 7 factors, and he does so in the subsequent paragraphs. The first of those factors is the one in which he refers to Chartbrook. First, the reliance placed in some cases on commercial common sense and surrounding circumstances, e.g. in Chartbrook, and he then cites the relevant passage of Lord Hoffman's judgment, should not be invoked to undervalue the importance of the language of the provision which is to be construed. The exercise of interpreting a provision involves identifying what the parties meant through the eyes of a reasonable reader, and save perhaps in a very unusual case, that meaning is most obviously to be gleaned from the language of the provision. Unlike commercial common sense and surrounding circumstances, the parties have control over their language they use in the contract. And again, save perhaps in a very unusual case, the parties must have been specifically focusing on the issue covered by the provision when agreeing the wording of that provision. So, my lord, the point I take from that is that he is not seeking to say anything at all about the Chartbrook exception, except to say it is an exception. And you cannot widen that exception and grow it into a general principle of judicial intervention to save people from their bargains, which is effectively the submission that Mr. Morshead was advancing in Ireland and Britain. And then, my lord, at paragraph 20, he returns to the contractual common sense point. Fourthly, while commercial common sense is a very important factor to take into account when interpreting a contract, a court should be very slow to reject the natural meaning of a provision as correct, simply because it appears to be a very imprudent term for one of the parties to have agreed, even ignoring the benefit of wisdom or of hindsight. So again, he is identifying in my submission the proposition that the Chartbrook exception does not run any further. It doesn't run as far as mere imprudence or mere great imprudence. And he goes on over the page to refer in the last sentence, accordingly, when interpreting a contract, a judge should avoid rewriting in an attempt to assist the unwise or to penalise an astute party. So to ameliorate good or bad bargains.
Well, that's the same point that Lord Justice Briggs was made in, I think it was Sugarman, wasn't it?
He did.
You have to draw a line between things which are unfavourable, bad bargains, imprudent, and things which are the other side of the line.
Yes.
Arbitrary, irrational,
correct.
Absurd. And we know the line isn't always easy to draw, and Lord Hoffman himself says that sometimes judges disagree about it in a particular case.
My lord, yes. But and in my submission, there is a telling point, and it's useful for to defeat the point that my learned friend makes in relation to the relevance of the contractual absurdity of the result. There's a telling point in the language which is used on one side of that line and on the other side of the line. The irrationality point, as your lordship referred to it, or using that term, tells you that what you're looking for is a situation where the outcome that the cause produces is inexplicable on any hypothetical reading of the background facts. It's not simply a bargain which is unduly favourable or unduly unfavourable. It is a provision which does not have any logical explanation. And if you have that, my lord, in the course of a clause, there may be other circumstances, and in this case there are other circumstances which can show you that it's clearly a mistake. But if you're simply looking at the outcome of the clause, that will tell you that it's arbitrary or irrational, my lord. So there is a distinction between the two. But my learned friend tries to characterise the argument which we're advancing as simply saying this clause is so onerous that it is clearly a mistake. That is obviously a factor, how onerous it is, but it's not simply that it's onerous. It is onerous in a way which cannot be explained by, for example, my learned friend's resort to the quid pro quos or the ameliorating effects of a break clause. And it is that factor which tells you, or told my lord, Mr. Justice Fancourt, that there was a clear mistake here. It wasn't simply a bad bargain. So I don't think I need to take you through the rest of the judgment, simply to point out that the structure of it, explain the structure of it. From paragraphs 24 to 29, he goes through the questions of whether there's an ambiguity to resolve in relation to that. And then at paragraph 30, having said no, there isn't, he goes on to say, were it not for the percentage increase of 10% specified, coupled with the subsequent history of inflation in the UK, that would be an end to it. So he's basically saying, we've dealt with ambiguity, that's an end to it. And then he goes on to consider from paragraph 30 onwards, whether or not looking at the contract in the context of inflation allows you still to intervene. And he reaches his crucial conclusions around paragraph 35, where he makes it clear that he's unconvinced that the bargain that was struck was in anything more than an imprudent one. And in 36, he makes the point, which I flagged before lunch, that all they did was take a gamble on inflation. Which is not the same thing as having agreed an irrational proposition. If inflation had continued to run, then there would have been nothing irrational. There would have been nothing at all to pin inflation on, which is the point he introduced at the beginning in paragraph 30. So, that's
this is 10% a year. When was 10% a year agreed?
The original.
Well, originally I think it was much less onerous. I think it was originally 10% every 3 years.
Well, there were some leases which were 10% a year, and some leases were 10% 3 years, and then they were subsequently varied, so they were all 10% a year.
Oh, I see.
But the leases started to be granted in the 70s.
Well, in 1973, I think inflation was 25%.
Yes, my lord, and that's the point which is being made, that they made a bad gamble in relation to inflation, but it didn't look bad from the tenant's point of view when the leases began to be granted, because at that time the inflation was completely credible. But even if they had made a bad bargain, what they were doing was gambling that inflation would be higher or lower than 10%, and that's very different to an irrational mechanism,
yes,
which isn't a sensible gamble on anything, or sensibly explicable as a gamble on anything, I should say. Well, I don't think I need to deal with Lord Neuberger's judgment any further. Turning to Lord Hodge, then. With whom it's right, as my other friend said, to point out that Lord Neuberger and those that agreed with Lord Neuberger therefore agreed. Again, I wish to take your lordship through the structure of it, but in fact all I'm doing is making good the submission, the point which my lord...
Just say that again about who agreed with who?
Many judges agreed with Lord Neuberger. Lord Neuberger agreed with Lord Hodge. So effectively everybody except Lord Carnworth agreed with both Lord Neuberger and Lord Hodge.
Thank you.
And indeed, to complete that circle, Lord Hodge agrees with Lord Neuberger.
He does.
In the first paragraph. So everybody agreed with everybody else except my Lord Carnworth.
Thank you.
So I was saying, my lord, that I'm going to take your lordships from paragraph 68 through the structure again of the judgment, but this is to make good the point which my Lord, Lord Justice Males had already made to Mr. Dutton, my learned friend, that what Lord Hodge does is he first of all considers the ambiguity point and reinforces the point which has already been made by Lord Neuberger, that in a non-ambiguity case you're not entitled to wade in, and then he goes on to consider whether this is a case where there is a clear mistake. And my Lord, we begin at 68. In the course of the debate, we were referred directly or by reference to several cases concerning the remediation of mistakes by construction or the implication of a term. In my view, they don't give the support that Mr. Morshead needs. So, in fact, what was going on was that Mr. Morshead was saying to the court, if you look at those judgments, and indeed the judgment in Aberdeen City Council, which is one that the third mentioned, which is actually an implied term case, Mr. Morshead was saying, where the contractual bargain has been falsified by events, the court can intervene. Yeah. And what Lord Hodge is saying is the cases to which he has referred, which are contractual correction by interpretation cases, don't lead you to that position.
Yes.
So he then cites Homburg and Chartbrook, noting in passing that he makes no suggestion in that paragraph that he is correcting or limiting the operation of Chartbrook, or disapproving, as my Lord Justice Nugee pointed out, disapproving the fact that Lord Hoffman's judgment is predicated on the basis that it's the result which is irrational. So no adverse comment in relation to that. So he goes through those cases. Then in 72 to 74, he essentially explains that the context doesn't assist anybody in relation to this case. Then from 75, he goes on, while there are infelicities in the language of the relevant clauses in some leases and no clear explanation of minor changes in drafting, I am not persuaded that the meaning of the language is open to question when the full weight is given to the very limited factual matrix which the courts have been presented with in this case. And he then explains that. And then he goes on at 76, this conclusion is not a matter of reaching a clear view on the natural meaning of the words and then seeing if there are circumstances which displace that meaning. I accept Lord Clark of Stone cum Ebony's formulation of the unitary process of construction in Rainy Sky. The existence of construction is essentially one unitary exercise in which the court must consider the language used and ascertain what the reasonable person, that is a person who has all the background knowledge which would reasonably have been available to the parties in the situation in which they were at the time of the contract, would have understood the parties to have meant. In doing so, the court must have regard to all the circumstances. If there is two possible constructions, the court is entitled to prefer the construction which is consistent with business common sense and to reject the other. This unitary exercise involves an iterative process by which each of the rival meanings is checked against the provisions of the contract and its commercial consequences are investigated. But he's still talking very clearly here about choosing between rival meanings and whether or not there are rival meanings, as my Lord points out. In Re Sigma Finance, forgive me, I stopped halfway through his citation. He refers to Re Sigma Finance for that proposition that it's iterative. But there must be a basis in the words used in the factual matrix for identifying a rival meaning. So this is where he's looking at the question of how you decide whether something is ambiguous. The role of the construct, the reasonable person, is to ascertain objectively, with the benefit of the relevant background knowledge, the meaning of the words which the parties used. The construct is not there to rewrite the parties' agreement because it was unwise, again, to gamble on the future economic circumstances in a long-term contract, or because subsequent events have shown that the natural meaning of the words has produced a bad bargain for one side. The question for the court is not whether a reasonable person and properly informed tenant would enter into such an undertaking. That would involve the possibility of rewriting the bargain in the name of commercial good sense. So we're still very firmly on the bad bargain side of the line, where commercial common sense is only relevant to choose between ambiguities. In my view, Mr. Morshead's formulation, on which this case depends, asks the court to rewrite the parties' leases on this illegitimate basis. Then he goes on, as my Lord points out, to consider the actual point which those cases address, the correction by construction. Nor is this a case in which the courts can identify a remedy, a mistake by construction, even if, contrary to my view, one concluded that there was a clear mistake in the parties' use of language. It's not clear what the correction ought to be. So he considers ambiguity, and then he separately considers correction by construction, but he really only deals with the second part of correction by construction, which is to say that there is more than one outcome. And then he goes on, the court must be satisfied as to both the mistake and the nature of the correction. And then he cites my Lord Newsburger's proposition and judgment in Pink Floyd, which your lordships will note in passing, we have already looked at this morning, and which shows that the outcome being arbitrary is a sufficient basis for deciding that the clause is irrational and needs to be a clear mistake. So my learned friend's submission amounts to saying that in citing positively Pink Floyd for one proposition, he is in fact overruling it in relation to another proposition without any indication of that in the judgment. And my lord, I say that this judgment cannot bear the weight which is being placed on it.
And Pink Floyd at 21, which he cites here, itself is a quote from Lord Hoffman in Charlton.
Yes, my lord. But my point is, it's not. It is not the passage in Pink Floyd where my Lord Newburger says one is normally looking for an outcome which is arbitrary or irrational, but it does immediately follow that passage and says accordingly at the beginning of it. So it would be very strange if the effect of Lord Hodges' judgment is to overrule the paragraph 20 point, last sentence of paragraph 20, in approving the paragraph which immediately follows on from it and which begins with the word accordingly, i.e. that paragraph 21 follows from paragraph 20. But that is the purport of my learned friend's submission.
Right.
So my lord, Arnold Britain has not changed the law, which was one of the propositions which I put forward beforehand. So that is the law before Arnold and Britain and the law during Arnold and Britain. My lord, the law after Arnold and Britain is simply to say nothing to see here, as it were, my lord. The subsequent judgments continue to cite the standards passages of the judgments on contractual interpretation and also go on to say, in an exceptional case, Chartbrook applies. And the Chartbrook two-stage test, only 2 stages, continues to apply in those cases. I've given the references to all of those in my skeleton argument, my lord. I don't propose to tax you with them, except to point out that I added into the bundle at 14 and 15 a more recent assertion of the same point in the FCA and Arch Insurance, which is the business interruption cases. And if your lordship has the index, which includes 14 and 15, you can see the paragraphs which are where it is cited again and indeed applied in those cases. In 64 and 65 and 47 and 61, the same rule is applied without any indication.
Now, mention of recent cases prompts me to observe that this court has this morning handed down a decision in a case called Britvic and Britvic Pensions, in which my Lord Justice Nugee sat, in which these cases, some of these cases, were cited. Our preliminary reading of the law is that those cases, that judgment, which of course includes my lord who sat on that case, is that hasn't changed the law. I don't know whether you have had
no, my lord.
You're probably not aware of it.
You're probably that's a dreadful moment. I remember once rising to my feet and Lord Justice Frederick Lawton made that very point to me, and I remember the blood rushing to my face. You're doing very well, Mr.
The blood is now rushing to my face, my lord. But I was heartened by the fact that you suggest that the law hasn't changed.
No, we don't think it has. But we just wondered whether you'd had a chance to look at it.
No, my lord, I haven't seen it.
Or Mr. Dutton. Well, we might give you a few days just to think about that and give us
my lord,
comments in writing, even if it's
as long as it's on,
even if it's nothing to see here again. We thought we might give you that opportunity.
Very well, my lord. I'm perfectly happy for that way to proceed, as long as there's nothing to see here, as it were. If there is, we'll obviously have to address it anyway, my lord. So,
yes.
I can say that from my point of view, we didn't think we were saying anything new, and nor were we addressed on the basis that Chartbrook had been qualified or amended or dissented from. by any of the subsequent authorities.
Well, this is, as far as I can work out, the first case where that submission has been advanced, up to and including the friend's submissions in Trillium, which we'll come on to in a moment. My lord, as far as I can see, nobody
What
has
the
suggested this
Arnold
paper.
Britain has watered down Chartbrook submission.
Or impose a limitation on it, that when considering the test, you can't simply consider what the outcome is. That's not alone.
Well, I don't think that point was run in the Britvic case, but then I've only read it on my phone, Mr. And I'm more confident my lord thinks that that's the case. But anyway, we'll probably give you 7 days to put anything you want to in writing.
Thank you, my lord.
Something Mr. Dutton may say. Yes. Now, where are we going now?
I think, to be fair to Mr. Dutton, he did say in terms that, in a sense, Arnold and Britain hadn't changed anything. All it had done underline the need for judicial restraint.
Well, he certainly said those words, my lord. He then proceeded to say that on the basis of Arnold and Britain, and that's certainly what his skeleton also says, this court cannot reach the conclusion that the absurdity of the outcome of the provision alone is sufficient to tell you that a clear mistake has been made, and that's not the law prior to Arnold and Britain. And in his skeleton argument, he refers to one of the tests, which is City Alliance. I think it's called Alliance of Assurance Alliance, and says if this remains good law, and he refers to the City Alliance line of authorities and whether that remains good law following Arnold and Britain. So, if my learned friend is saying that the law hasn't changed, then I needn't trouble you any further. But I understand his skeleton argument, and in fact, the weight of his submissions to be that there is a change because the City Alliance is no longer good law. That's what his skeleton suggests.
Would it assist if I may try to make things a little clearer?
Well, I think actually, we'll wait till your reply.
Yeah, that's absolutely. Yeah.
Well, I think we're clear about what you said.
I'm grateful, my lord, even if I'm not.
Okay. So where we get? You want to take us to Trillium? Do you?
Very briefly, my lord, only in part to assist my learned friend in relation to it and correct something which he said to the court. I think the learned friend may have confused two cases, which is he's absolutely right that the passage which he cites in Trillium, paragraph 16 of the judgment of my Lord Justice Lewison, is the point at which Lord Justice Lewison points out that even if there was an error, it's not clear what the correction of the error is. And that's absolutely one of the several reasons why his submissions were rejected in that case. However, what he's not right in saying is that the provisions in that case were materially identical to the provisions in this case. In that case, and my lord, you can just give me a second while I turn up my relevant notes on this. It concerned index-linked rent review provision in a reversionary lease. There was an original lease granted in '86 and expiring in March 2010, which provided for 5 yearly rent reviews. The first of those reviews increased the rent to £1.6 million, and it remained like that until we get to the December review, at which point various new instruments were executed. A memoranda recording that the rent was £1.16 million until September 05, and providing that the rent for the rest of the term would be £965,000, and deleting the final review. At the same time, they entered into a reversionary lease, so a lease to follow on from the lease which was already granted, and it was in that the rent review mechanism that was under consideration existed. He said that the provision was the same, but in fact the provision in that case was that the annual rent for any review period was to be determined at the relevant review date by multiplying the initial rent by the index month preceding the rent review date and then dividing by the base figure. So in a sense you have it's the initial rent multiplied up by the RPI at the time divided by something else. And the thing that was contended for as an error was that the base figure was specified as a number. So not specified as the RPI on a particular date, but a number. And the number was 193.1. And that was the base figure for RPI back in September 2005, at which point the rent was 965, not £1.2 million as it became. So the contention was, what they've done is effectively applied inflation from a point where the rent was this, but applied forgive me, I'll start again. They've implied a multiplicand starting with an assumed rent, but that wasn't the rent at the point where the RPI, which is being divided by the new RPI, actually applied. So there's a temporal mismatch, as it was put by my learned friend to the court, between the two dates on which the RPI actually applied and the rent. And in that context, what Lord Justice Lewison said was there were several different corrections in relation to that which were available, because you could correct the date of RPI and therefore the figure for RPI, or you could correct the rent, and they wouldn't produce the same results in those circumstances. So it was a fault in relation to a rent review clause which worked on the basis of RPI, but it wasn't the mistake which we're dealing with in this case. And in that case, there definitely were several different ways of correcting it on any view, and that's the reason why it was rejected. So I dealt with that in some detail simply to point out that it's not a case like this where this clause was reviewed and where the court concluded that there were several different ways of mending it, which seemed to be the way in which it was being presented to the court. It may be that my learned friend was confusing it with the facts of Westpac.
No, I'm not.
I'm grateful. Well, in Westpac, that was a decision of the Court of Appeal of New South Wales.
Yes.
And that's the one which did consider a clause.
That's the one which you say is closest to this case.
Exactly. And because it has exactly the same fault in the mechanism that this does. It repeatedly applies RPI each time there's a review for the whole period of the lease since the last thing to the passing rent rather than the initial rent. So that's the one which does have the same mistake as this lease. And in that case, they found that that was absurd, the word that they used. So, my lord, those are my submissions on the law. I turn to the two points that my learned friend grouped his submissions under after the law, which is no clear mistake, not clear how the mistake should be corrected. So in relation to there being no clear mistake, his submission, one of his submissions was that the court has insufficient knowledge of the background to know whether this was a mistake at all. And he referred you to the possibility that the rent had been discounted. And he says there wasn't sufficient evidence before the court to allow that possibility to be discounted, and therefore it may not have been a mistake to include this clause. There is effectively a prior misunderstanding on my learned friend's front, because there was in fact evidence. There was the evidence which is recited by Mr. Feekins in relation to the rent, and then there was the evidence that was excluded, which was put before the court in relation to other similar leases and what the rent was in relation to that. That was excluded by my Lord Mr. Justice Fancourt. So there was evidence. There wasn't expert evidence in relation to the valuation, which is the point that Mr. Justice Fancourt actually made in relation to that. He did consider a different submission in relation to the break clause. So what was advanced by my learned friend's predecessor was that the break clause ameliorated the onerous provisions of the lease, and you were taken to the break clause. You weren't taken to the provisions of the lease which point out that at the point of the break clause, the land has to be remediated. And what Mr. Justice Fancourt said of that clause is in paragraphs 61 and 62, but I can take you back to this, my lords. It's behind tab 5 in the core bundle.
Yes.
We begin at 61 in the second sentence. The lessee's break option means that the lessee could escape the more extreme consequences of the formula. Now, this is in the context, your lordship asked at the beginning whether there are any examples. At the beginning of the lease, he points out that if you applied the historic average rate of inflation, you end up with a lease with a rent of £76 million a year, having started at £1,000 a year. My lord, so that's the extreme consequences of the formula that he's referring to. but at the expense of dismantling the apparatus and possibly having to reinstate the land. That is because the lease gives the landlord the option to require removal of the apparatus and reinstatement. Those provisions are separate from the tenant's right to remove its own trade fixtures. The exercise of the break option would mean that much of the cost of the apparatus might have to be written off by the tenant over the uncertain number of years, possibly significantly fewer years than the 25 years of the lease. Although the presence of the break option gives more balance to the lease in commercial terms and might have been considered adequate protection by some lessees, it does nothing to mitigate the irrational and arbitrary way in which the lease formula operates, just because it provides the lessee with an escape from its worst ravages. It doesn't explain why, objectively, the landlord would have required a rent review provision in such terms if it wasn't a mistake. This is the fundamental problem with my learned friend's suggestion that there might be quid pro quos elsewhere that we don't know. No quid pro quo addresses the fact that this provision is irrational. And that again goes back to the mischaracterization of the respondent's case, which is this is just such an onerous provision that it's obviously a mistake. It's not that it's merely onerous, it is irrational as a provision. It is arbitrary in its effect.
Yes.
My learned friend made the point in relation to the fact that this vehicle was an SPV, to which the lease was granted was an SPV, and he referred to my Lord Justice Fancourt piercing the corporate veil.
Yes.
There are submissions in Musco's argument in relation to this. There's no piercing of the corporate veil. What my Lord Mr. Justice Fancourt did was correctly identify the matrix of fact in which this lease was granted. It was granted in order to provide a development opportunity into the lessee of a potential wind farm site. And that was one of the facts which is identified, or part of the facts which is identified as being relevant material from the much wider band of facts which were mostly not relevant material by Mr. Justice Fancourt at paragraph 25. And then at paragraph 63 of his judgment, he explains the potential relevance of that. And I raised this simply to deal with the fact that my learned friend said in the end he decided it wasn't important. Actually, what he did was he refers to it in paragraph 63 to say, because what is going on is the lease is creating a development opportunity, and the lease will then have to be sold to someone as a development, and that was the context. Making a lease which has got a completely crazy rent review clause is not good for the landlord either, because he's then got to have to sell it.
Sale price.
It will reduce the sale price or make it unsaleable, one of the two. Yes, my lord. What he does also say, in fairness to my learned friend, at paragraph 65, is that in the second sentence of that paragraph in line 5, this is a conclusion that I would have reached, taking into account evidence of the economic background, regardless of the admissibility of the particular background facts about the circumstances of the grant of the lease to which I have referred. So he says he has relied on it, but he says that had that not been the case, he would still have reached the same conclusion that it's a clear mistake. So it's not quite the same thing as saying it's irrelevant, that it was that it didn't matter.
Right.
So, my lord, that's the point about arm's length transactions. There's nothing offensive about referring to the fact that the grant of a lease is in the context of a particular development opportunity, which is all he has done. Then the fourth...
It's probably my fault, Mr. Watkin, but I haven't quite understood why the lease was granted at all. The landlord owns the land.
Yeah.
The landlord gets planning permission for a solar farm.
Yeah.
The landlord then gets a grid connection, which you need, which is very valuable.
I think actually that's the tenant that gets the grid connection.
Well, whatever it is.
Yes.
What the landlord's trying to do is to monetize the planning permission
Yes.
by finding someone who wants to take a lease of the land.
No, well, yes and no, my lord.
But why do you put the lease in place before you market it? Why don't you
You,
just say?
you just sell the lease for a capital sum, my lord.
Well, what's the difference between that and saying, if you want to have a solar farm, I'll grant you a lease at a premium?
Nothing at all, my lord.
So why do you put it in place first? Is it a stamp duty point? Is it...
I simply don't know, my lord. I simply don't know. These, as I understand it, these are sold in the form of SPVs. So I suppose you could. So the SPV is the one that's transferred, and your lordship may say that that has a tax advantage rather than assigning the lease or granting the lease.
Well, I wondered if it was tax was behind it.
There may be tax behind it. I simply don't know, my lord.
We don't have any evidence.
No.
It just seems a slightly odd thing to do, to set it up before you've got a purchaser.
My lord, I think I'm right in saying I have a solicitor behind me who knows quite a lot about this, and I can take some instructions on it. But
Well,
I think I'm right in saying that this is the way in which this is in fact done. But why it's done in that way, my lord, I'm not sure.
I don't think we should be taking new evidence. I just wondered if there was anything in the material.
Nothing in the material before you. I confess, I can't now remember. There was quite a lot of material which went in. The way in which the material was dealt with, just to remind your lordship, was that Mr. Feekins put in a witness statement which was suggested not to be subjective intention evidence, and we said it was and should be excluded, but it's also all wrong. There wasn't a discount, this thing is wrong, that thing is wrong, his statements about historic inflation and the rates of increase of electricity prices all wrong, and we put in a lot of evidence to show that that was wrong.
But it was in the event it was
in the event,
excluded.
Most of what Mr. Feekins was
So
excluded.
most of what you said was
Yes, and that happened ultimately by consent because my learned friend's predecessor was ill just beforehand. So there was going to be an adjournment. Mr. Justice Fancourt then said, well, I could deal with this on paper, but for this point about the inadmissible evidence. And there was then effectively a deal whereby if they withdrew the bits that we said were inadmissible, we'd trump all the stuff which we put in to reply to it, essentially. So that's how it came before the court. So there was a lot of material at one stage. And I can't now remember either how much of that material was accepted by the parties to go before the court. And I can't remember whether in that subset of material there was any discussion about whether these things are always traded by as SPVs. But
the upshot is that you are the original tenant, but someone has bought your clients have bought the shareholding in
yes, we bought the SPV, my lord. Yes.
Yes. So there's been no assignment of a lease, but you've effectively become the owners of the lease.
Yes. Well, thinking about it from the point of view of the first owner, because I think we're actually a subsequent purchaser of the SPV.
Right.
But think about from the first purchaser who isn't Mr. Feekins' company. What's happened is there is an SPV which grants a lease for 25 years of a piece of land, which has the ability to put a wind farm on it. So they are then by the SPV which holds this lease, in order to be able to invest in the construction of their wind farm into the site. So the relevant material fact is really that there isn't a wind farm there when the lease is created. And then if anybody wants the lease in order to be able to create a wind farm, they're going to have to invest in a lease which has this clause within it, which might mean that their investment disappears in a puff of smoke, depending on what inflation does.
Thank you.
I'm not sure whether I've answered your question or not, my lord, but that is where it takes us. I'm not sure it takes us very far, my lord.
No, thank you.
Right, so
that's the arm's length point, my lord.
Yes.
The fourth point is my learned friend's submission that you can't conclude that there is a mistake in the drafting, as it were, because there might be a prior mistake. The mistake may simply have been recorded faithfully, but the mistake occurs before that. And my lord, that is a category error. The question for this court is whether there's an error in this lease, judging this lease objectively, not why is there an error in this lease, or how did the error get into this lease. My lord, that same submission was actually rejected. I don't think it's been made since, but it was actually rejected in Manai, my lord. So I'm afraid it's necessary to take your lordships back to an authority. It's behind tab 2 in the first bundle of authorities. Page 722. Forgive me, 772. This is in the judgment of Lord Stane, and it's the middle paragraph in the page, and I'll just read it, my lord, while your lordships are finding it. It is necessary to turn briefly to, just actually before I do, my lord, I'm sure everybody is aware of the facts of Manai, but there was a lease which required a break notice to be served, which was expressed to expire on the 3rd anniversary of the lease.
Yes.
Which was in fact the 13th of January.
Yes.
And the lease notice that was served actually expressed itself to expire on the 12th of January, but was nevertheless held to be a good notice. In that context, my lord, I read, it is necessary to turn briefly to other arguments advanced by counsel for the landlord. He argued that the tenant's construction argument must fail because the tenant's error may have been due to a mistaken legal view. He said that it may not have been the case of a mistaken insertion of the date, but the tenant may have intended to refer to the 12th. In other words, he may have thought that the 12th was the anniversary, not that he got the date wrong. This reveals a contradiction in the landlord's argument. Counsel for the landlord accepted that the test is an objective one. How would a reasonable recipient have understood the notice? But then he invited your lordships to speculate that the tenant's error was due to a mistake of law rather than a typing or clerical error. That argument, if accepted, would drive a juggernaut through the objective test. Speculation about the subjective intention of it is irrelevant. The only question is how a reasonable recipient would have understood the notice. So you don't have to worry about whether or not the notice and the thinking behind the notice was erroneous. That trespasses upon the subjective evidence. All you have to do is to construe the notice. That is the answer to my learned friend's submission. Well, it might have been a mistake in the thinking behind the lease rather than the lease. Doesn't matter. Short of a rectification claim, the thinking behind the lease is irrelevant.
Can I just test that? I mean, we're all agreed that what charge is about is correcting mistakes.
Yes, my lord.
A mistake is where what appears on the page isn't what should be on the page, putting it as neutrally as possible.
But it's construed from the objective. What did they actually mean when they wrote these words on the lease? Look at the lease and construe this lease or this development agreement.
It's not what did they actually mean in the sense of what did they subjectively intend. It's how would a reasonable objective observer interpret the words that appear.
Correct. Yes, my lord.
But in order to get into the chart book analysis, the reasonable objective observer has to conclude that it's clear there's been a mistake. So he has to conclude that what's written isn't what should be there.
Yes, my lord, but he doesn't have to conclude that it might. He doesn't have to consider whether or not the reason why it shouldn't be there is because it crept into an earlier draft and was never removed, or because it was a mistake in the heads of terms. It's simply an objective analysis of the document itself.
Does he have to be satisfied that it's something's gone wrong in the writing of it, or something's gone wrong in those mathematical understanding? One of Mr. Dutton's points was, the judge got the maths wrong. Maybe Mr. Feakin's got the maths wrong. The objective observer doesn't know.
He doesn't need to know, my lord. The question is whether objectively the objective observer may reads the document and construes what the objectively single meaning of that document is. And he excludes, we say, the possibility that, or he includes the possibility that a mistake has been made and that they didn't mean what they said in that provision. But in order to make that conclusion, he doesn't have to consider whether or not how the mistake arose. And that is exactly the error which was made in Manai. He doesn't have to consider whether the error might in fact have been that the person who drafted the notice didn't understand what the anniversary of the lease was, which is the same thing as your lordship's case in Chartbrook. Didn't have to consider whether or not they thought that the formula would produce the right number for them, but didn't understand how it worked. Or in this case, they couldn't do maths. The objective observer can do maths. He can construe a document, and he can consider whether or not, rationally speaking, that is a document to which the parties can have agreed, or whether or not they must have meant something else.
Yes, okay, thank you.
So are we in Manai? Have you finished with
My lord, I finished with Manai.
Right.
So we turn to, that's effectively a number of the points. The fifth point is in relation to the existence of a mistake or the signs of a mistake at all. So my learned friend says, I'm wrong to rely upon the arbitrary and irrational nature of the product of the clause. And he then says there's nothing else in the lease which suggests suggests that a mistake has been made. And the only thing is paragraph 4.2, he says, and 4.2 is explicable. My Lord, I don't think there's much purpose in me vociferously agreeing with you about the question of what reflecting RPI means. I simply make the point that arithmetically, the fact that there is an arithmetic relationship which can be expressed does not mean that every such circumstance is a reflection of the increases in the cost of living. So, for example, if the formula had said it increases by the inverse of RPI, so that as RPI went up, the rent went down, inevitably, and the other way around, it would be bizarre to characterise that as reflecting increases in the cost of living, my Lord. So there are distortions and distortions, if I say, without descending into the mirror analogy any further. But there are other factors as well, my Lord, which weren't discussed by my learned friend. They are discussed in my skeleton, but I briefly mention them now. The first one is the very use of RPI. The arbitrariness of the clause, if the clause is going to have an arbitrary effect on inflation, it seems an odd thing to do to pick an index of inflation to apply at all if you're going to effectively generate random increases in the rent. So the fact that they were picking an index of inflation rather suggests they were intending one to follow the other.
As opposed to saying the rent would increase by a fixed amount a year, for example.
Or something else, yes, absolutely. But the second point is the use of the word indexation, which occurs several times, in particular in paragraph 4.2. The new arrangement for indexation. Indexation has a meaning. It means the increase of one quantity automatically by the same ratio as an increase in another quantity. My learned friend used it in exactly that sense.
Does indexation mean increase or change?
Or change, my Lord, change. And I'll come on to the increase and change distinction in a moment, but your Lordship is right to pick me up on it, and that I perhaps make my own later point in that error. But my Lord, indexation is the tracking of one quantity by reference to the changes in another index, in fact. And my learned friend used the term in that sense in the course of his submissions. He referred to normal indexing and simple indexing. Indexing implies the fact that they're calling this thing indexing indicates that they are intending one to track inflation.
So index linked means something which matches rises in the index.
Yes, it increases with the ratio.
Or falls.
Changes with the same ratio that the index is changing. Yes.
You wouldn't say that the rent that we've got here is index linked, even though calculation involves looking at the index.
Uses the index. It would be rather like saying, well, you multiply the index by 0 and then apply that to the rent. Well, I mean, you're using the index. It doesn't mean that the product has got anything to do with indexation or anything like that. Or, as you say, my Lord, it wouldn't be index linked if the rent went up by the inverse of RPI. It wouldn't be index linked and you wouldn't be indexing. My Lord, because your Lordship mentioned the felicities of the drafting and the relevance of the fact that it had been drafted by an amateur, my Lord, if I can respectfully refer to Mr. Dickens in that way, I would point out, as you know, that there are several remarks about the greater degree of confidence that you can have that intervention is necessary in circumstances where the documents are poorly drafted. In my skeleton argument for the first hearing, I listed all of the errors in the lease. It might be just worth pointing out some in Schedule 6, since you have it open, I hope, my Lords. But, for example,
Just before you do that, do you agree with Mr. Dutton that the fact that Mr. Feekins drafted it himself, saying he took it off the internet, is inadmissible?
Yes, it's detail of how it came to be produced, rather than it's effectively evidence of the negotiation of the lease, rather than...
So how do we know that it wasn't professionally drafted?
You don't, my Lord.
We don't.
But the quality of the drafting is the issue, and you can tell the quality of the drafting by looking at it, my Lord, which is what I invite you to do.
Even things which are professionally drafted often.
They do, my Lord, and the worse that they're drafted, the more the courts are willing to intervene. Not that this case is going to turn on that point.
So the amateur professional point, A is inadmissible and B is irrelevant.
The quality of the drafting is that if there is any relevant factor,
the fact that
the quality of the drafting.
whether it's not a lawyer
Yes.
Doesn't matter.
No, my lord. But there are things in the schedule. When you're trying to see whether a mistake has been made, the fact that there are other mistakes in the document is plainly a pedal balance.
Whatever the qualifications of the person who drafted them,
Correct.
the mistakes are there.
Yes, my lord.
And you're going to show us one. You're very keen.
I'm going to show you a couple which are around the provision that we're talking about, my lord. I'm not going to take you through all of them.
Okay.
But for example, it's not really a mistake, but it is an oddity about the drafting of the lease. It specifies the initial rent by multiplying a stated area by a stated amount.
Where are you?
Instead of just saying 15,000.
Correct. Yes, my lord. That's on page 80, my lord, in the definition of rent, which really means initial rent in this context. So that's one, my lord. But the greatest of the howlers, if I can, with respect to Mr. Pickens, refer to it in that term, is the last provision of this schedule, which rather spectacularly says 7. Time and not of the essence. Time is of the essence for the purposes of Schedule 6. So in the heading says time not of the essence, and then the provision says time is of the essence.
We're not asked to decide which is right.
No, my lord, it doesn't matter. It's simply an indication of the quality of the drafting.
I suppose the way in which the rent is expressed is not an error, it's just an overcomplication. And you might say that feeds into the formula in the for the revised rent. That is overcomplicated. And in overcomplicating things, you say it's gone wrong in the way you rely on.
My lord, yes. I mean, there are other, as it were, external indications, and your lordships may have picked up that this is not an unfamiliar error. This is an error which is, there are two different textbook, well, one is a textbook and one is an article in the back of your bundles of authorities, both of which warn the draftsman of exactly making this error, my lord.
It's an error which has extended all around the world to New South Wales.
Indeed, my lord, yes. It could not have got further away from its retail price index. But my lord, the first of those is behind tab 17, which is an extract from Lewison's Drafting Leases, which is now edited by Janet Bignell, QC. And she makes the point behind tab 17, the final page before the next tab, at the end of the first complete paragraph. 4 lines up, as your lordship have that point, it says one unfortunate error which is made from time to time is that the indexation relates back to the beginning of a lease, so that inflation is double counted. Although this may not be noticeable in the early years of the lease, the compounding effect over time may be disastrous.
Where is that?
My lord, it's behind
tab 17, page 129.
Oh, yes.
First whole
Yes.
under the general title, as you can see at the top of the page, my lord, index linked rents. So it's an error which crops up when you use index linking. People get the nomination of the numerator incorrectly specified.
And you want to take us to tab 20?
The second example of that, the error being noted, is behind tab 20, my lord. And this is an article from the Estates Gazette, and the relevant passage is highlighted at the bottom of the page under the words the base figure.
Do we know who read this?
My lord, Bill Chandler is a professional support lawyer at Hill Dickinson LLP, it says at the end. So I assume Bill Chandler wrote it, my lord. And it got past the editors of the Estate Gazette, my lord, in terms of the authoritativeness of it.
Does that make it authoritative or not?
Well, nothing at all, my lord. Merely notorious, I would say. Notorious error.
In 2018.
2018.
It says at the bottom of the page that the table below illustrates it, but we don't have a table.
We don't have the table, no. Unfortunately, the way in which the article is produced doesn't include the actual table from the actual magazine. The online version hasn't preserved the table, unfortunately, my lord.
Thank you.
Yes.
Do those references to the well-known error help us as to how it should be corrected?
Well, if you're trying to consider whether or not it's clear that an error has been made, the fact that the error is one which is notoriously
Yes, I
easy
agree.
to make in relation to
Do
release.
those authorities or any other authorities indicate how the error should be corrected?
No, my lord. They simply point out that if you don't use the correct formula by making the error that we are making, you will be making an error.
You're in trouble.
Yes, my lord. And as we will come on to, my lord, in the next set of submissions, there is only one way of correcting the error, which can be expressed in several ways, unless it's an upwards-only rent review clause, and that's common ground, my lord. So you don't need to specify
the articles in the book you just showed us don't say, don't worry if you make this error because the courts will step in and correct it, applying Chartwell.
They don't say that. It might be said to be poor advice in the drafting of leases not to worry because the courts will save you from your negligence, my lord. But I speculate that may be the reason why they don't point out that if you do make this error, someone will save you from it.
Also, you always have to face an argument.
Surprisingly often, my lord, in relation to this point.
Yes. Yes.
So, my lord, those are my submissions in relation to the first of the two questions. Is there an error? And the second one is it's not clear what error was required to be corrected. Forgive me, what the correct correction is required.
Yes. And your point is, there are various ways of expressing it, but they all mean the same thing.
They all mean, and I think my learned friend accepts this.
If it's upwards and downwards,
correct. Yes.
then it doesn't matter how you do it, you get the same result.
Yeah.
But if it's upwards only, it does make a difference.
It does make a difference. Yes, my lord.
Whether you go back to the beginning or take
Correct.
the passing rent as your starting point.
Yes, my lord, it does.
Yes.
The case would advance before, positively advanced before my lord, Mr. Justice Fancourt, that it was in fact upwards and downwards, because some.
I can see Mr. Dutton shaking his head.
Well,
Anyway, he's not been advanced that way.
If I have to, my lord, I will go through the provisions. I've done it already in my skeleton argument.
All right.
But does it matter?
No, not really. No, my lord.
Well, I mean, this is a question of construction.
It is.
Questions of construction are questions of law.
Yes, my lord.
And
I'm not saying he's shut out from raising the point, my lord.
evidence as to how a legal argument was run by somebody else below doesn't bind us.
I agree, my lord.
Yes.
It is simply to explain the reason why there are two judgments in this case, and it's the second of these judgments which deals with the point, subject to the point which your lordship has already made, which that Mr. Justice Fancourt was perfectly content with it being an upwards and downwards provision originally when he proceeded with it, and that would not be a difficulty. So, my lord, that's the reason. I'm not making it either to try and shut my learned friend out or to score a point against my learned friend's predecessor in not having raised it before. I raise it to point out that there are two judgments in this case. The first one dealt with it on the premise that it was upwards and downwards. The second one deals with it on the basis that it's upwards, the postulation that it might be upwards only.
Yes.
So that's the only relevance of that. And he does so, my lord, at tab 6, paragraph 8 onwards. 8 and 9 are dealing with the fact that it's a change of position, and for the reasons your lordship has just indicated, that doesn't really matter. But paragraph 10 onwards is what he says. Be that as it is may, the defendant now argues that it cannot have been clear that the mistake was one which I identified, because there's another possible meaning that the parties might have intended for Schedule 6 to have. But the relevant question is not whether, divorced from the context of the other terms of the lease, it's possible that the parties in the position of the claimants and defendants might have agreed an upwards-only rent review. Of course, they might have done so. The question is whether it is unclear what mistake these parties made, because, objectively, they could have meant that the rent should increase but not decrease in line with RPI. Mr. Dutton relies in this regard on the terms of paragraph 4.2 of Schedule 6, which states that if the RPI ceased to be published, a new arrangement for indexation should be agreed so that the rent to be calculated shall reflect increases in the cost of living on a similar basis. I do not consider that this is anywhere near sufficient to suggest that the party's mistake could well have been in failing to provide for upwards-only RPI views. The necessary correction must reflect the nature of the mistake. The mistake was to specify the wrong base index figure, which had the unintended result of repeating each annual RPI adjustment to the rent on every succeeding rent review during the term, A failure to state that each rent reviews should have upwards only effect would be a further mistake, different in kind from the mistake that I held was all clearly made. There is no suggestion that by omission the parties made that mistake too. The use of a cost of living index such as the RPI suggests the opposite. The points that I wish to make on this point in support of those conclusions and the paragraph that follows it. Firstly, there is just, as Lord Justice Nugee already said, there's just nothing there in the mechanism directing the parties to produce an upwards only provision. And it's not a difficult thing to do. Of course, that doesn't mean that there isn't another mistake, but it does mean that there's a different mistake. The second point to make, and I simply endorse again what my Lord Justice Nugee said, there is no support to be taken in relation to this area from paragraph 69 of the first judgment in this case, where under the misapprehension about the way in which RPI works, Mr. Justice Fancourt talks about alternative ways of correction.
Do you understand what?
I understood. I read it,
what he was thinking.
Yes, I read it exactly the way that your lordship read it. What he is saying is there might be a disadvantage in relation to one rather than the other, because one is applying effectively simple interest, and the other one is applying compound interest, and that is and he then goes on to justify why you choose one rather than the other. But what he's dealing with is his misunderstanding that RPI is compounded internally already. As my learned friend explained to your lordships earlier on, if you start with a base of 100 and it goes up by 10% each year, you get 110 as your base in year 1 and 121 in year 2. And he hasn't understood that. So that is the point which he is grappling with in order to try and avoid there being more than one way of correcting it. He thinks that is the difference between the two ways of correcting it, which is not right. There's nothing in there to suggest that he's suggesting upwards only, and as your lordship points out, he plainly was working on the basis that it wasn't upwards only in that very paragraph. So where do we look for the conclusion or the premise that this is upwards only? My learned friend points to Schedule 6.
Yes.
And the references to increased rent.
4.2.
Well, increased rent is in the definition of revised rent.
Yes.
And 4.2 increases in the cost of living.
Yeah.
I think there was a third one, wasn't there?
There's a
In 5, the fact that you have to pay the extra if you've underpaid.
Well, that's a separate point. That's a separate point. If I can deal with that, the first one he raises is the references to the word increase. The second one, as your lordship correctly points out, is the payback provision, which I'll come on to, my lord. In relation to the increase point, Mr. Justice Fancourt accepted our submissions. This is simply a normative description of what the cost of living does and what the rent is expected to do.
You used the word normative twice in your skeleton, and I have to say I don't understand what it means.
It means that it is a description which, a label or a description which is used based upon what the thing normally does. So cost of living normally increases. Inflation normally goes up. That's why we call it inflation, not inflation stroke deflation. So a normative label is one where the label itself is describing the usual effect of how the thing operates.
Well, that's very interesting. It's not what I would have understood by the word normative.
Oh, right. Well, that's the way in which I have used it and how I understood it. So
I thought normative meant in accordance with norms, meaning
yes,
laws.
exactly, my lord.
laws.
Meaning laws rather than what normally happens. But it really doesn't matter. But what you mean is,
It's a
inflation usually goes up.
So it's
That's
called
why
inflation.
we call it inflation.
Yes, my lord. And in fact, we even refer to, indeed my learned friend's predecessor referred to, and I think one of your lordships referred to this afternoon, or this morning, negative inflation. Which, of course, if inflation can only go up, is a contradiction in terms. Growth is the same term. So growth can be negative growth. And we simply say the use of the word increases is in the same category. You might even refer to negative increases in the rent if you were wanting to be totally pedantic about it. But whether or not the label increases is as flexible as the word inflation is, the same point applies to all of them, which is that they are using it to describe what will generally occur. The second point is, my lord, the point that Maloney Frame makes about paragraph 5, which is the payback provisions. In my submission, there are two reasonable explanations. One of those is advanced by Mr. Justice Fancourt, which is that because inflation goes up, has gone up for 40 years,
Subject to 2009.
Subject to 2009, it's not entirely surprising that they didn't make provision for something which they may have just discounted as being such a rare event that they didn't need to. The second point to make is they didn't need to.
I'm surprised you say it's only done it in the last 40 years.
My lord, I thought that's what you said. I thought that was the point that you made before lunch.
No. Well,
That it's been positive for the last 40 years with the exception of 2009.
I'm not sure I meant to say that, but I thought it. No, I said since the 1940s.
Oh, forgive me.
There's a case in 1948 which describes the temporary phenomenon of inflation.
You've only, my lord.
Just taking a long view.
Yeah. Yes.
But, my lord, so that
Okay.
the first explanation is the obvious explanation, which is they weren't expecting the rent to have to go down because inflation has historically gone up. There's another explanation, however, which is that you don't actually need the clause, because if the rent goes down and the tenant is overpaid, it will correct itself the next time he pays rent. You can just pay less rent. Whereas if the rent goes up, the tenant will have to pay more. He won't ever catch up in that sense. So it matters in one direction and not in the other direction, whether there's a payment provision. Do I need to explain that again, my lord?
Well, he's in credit. He'd be in credit.
He'll be in credit.
He would have overpaid. You can simply
He can simply pay less
deduct it
from the next payment of rent.
because it will turn out that he's overpaid, and he doesn't need any mechanism in the lease. He's got a legal right of self-help, as it were, simply on the basis.
Set off.
Well, it's not really a set
Well,
off.
not
It's just,
that, but yes.
I've already paid you.
I've already paid you that rent. Exactly, my lord. But the other way around doesn't work because the tenant never has to pay the money again unless he's directed to pay the money. He's already paid the rent for that year.
Oh, I see. Is this an annual rent? Or quarterly?
It's paid biannually, yes. It's paid half yearly on an annual rent, my lord, yes.
Right.
So if the tenant's underpaid, we need a mechanism to make him catch up. If he's overpaid, he'll catch up automatically by simply not paying as much rent the next time. So actually, you only need the mechanism in one direction.
Is that the explanation that Mr. Justice Fancourt gave?
No, he gave the explanation that they obviously just
Didn't
thought
think
it was
about
such a rare event that it wasn't worth making a provision for, wasn't necessary to make a provision for it, which is a perfectly rational proposition. So we say that this is all a very weak prop to build the submission that the lease intended an upwards only rent review mechanism. However, the real point is that, as my Lord Justice Bales pointed out before lunch, and as Mr. Justice Fancourt found, this is a mistake which operates independently of the lease. There's still a problem, even if you don't correct the rent review, if you think it's an upwards only rent review. It's a new mistake. It's not correcting the mistake that we're looking at. It's a totally different mistake. So in relation to that, you have to reach a conclusion about whether it's an upwards only rent review. There isn't an upwards only provision in the lease, so you're having to correct the lease. So you have to apply your two-stage test to whether or not to include an upwards only rent review provision in relation to that independently operating mistake, a mistake which continues to be a potential mistake, whether or not we had this other mistake in train. Because as it was pointed out, the rent could in fact go down in the first year rather than up in the first year if you happen to start it in a year when there was negative inflation.
Well, this might not be a case of Chartbrook type mistake. It may be simply construing a lease which has some indications in it that it's upwards only, but not enough to displace the basic rule that it's not.
Well, we say the literal meaning of the lease is clear. It's not an upward-only rent review. So if the literal meaning is clear, you have to apply it unless the two stages of Chartbrook are applied. Those two stages are, is there a clear mistake? No. And is it clear what the correction should be? No. There isn't a clear mistake because these indications are flimsy. It's not clear what the correction is because it's not clear whether or not you have to add a upwards-only mechanism, or you have to make more clear that when they say increases, they mean increases or decreases. So you can't insert an upwards-only mechanism into this lease. And if there's no upwards-only mechanism in this lease, there is only one way of correcting it. Which was, I think, your lordship's point before lunch. There is the lease has to, you have to consider the question of whether the upwards-only review has to be inserted anyway, because it makes a difference on other circumstances as well. So you're just applying the usual tests to the question, is this lease upwards-only or not? The two are not otherwise interrelated.
Yes, I was only making the point that the question whether it's an upwards-only lease may be the more conventional exercise of construction, where the argument would be that you've got ambiguity, and the answer, I don't know the answer which you would give, is that there isn't enough ambiguity to make a tenable case that it is upwards only.
Yes, my lord.
And therefore you're...
well, there is no ambiguity in the sense that the formula, as my learned friend says, is absolutely clear and it's a fact.
Yes, but by the time we get to this question, whether it's obvious how a mistake should be constructed, you've already succeeded in persuading us that there's a mistake which needs correcting. The question is it obvious what was intended to be there? The point that I understood Mr. Dutton to make was this. Once you've decided to get rid of the existing formula because it's mistaken, you're left sort of free-floating. You don't really have anything to grab hold of to know whether it's upwards only or not, and then you look at the other indications.
But that presupposes that what you do is you conclude that there is a mistake, a particular mistake, a specific mistake. Because there is a specific mistake, you can disregard the whole of the rest of the wording of the lease until you've got back to the conclusion of what it is, and go back. He kept on talking about the purpose of the clause, as if once you've got to the trigger of there being a clear mistake, because of the red ink point, you can correct the lease in any way you can. So it's now a free-for-all to decide what other mistakes need to be corrected. That's not right. The question is, right, the lease has a literal meaning, but there is a mistake. You concluded that there is a clear mistake in relation to literal meaning. Okay. Are there two clear mistakes in the literal meaning? If there are not, then the answer to the first correction is also clear.
Do you have any preference, if we get to this stage, as between your original formulation and the judge's formulation?
No.
It doesn't
they make no difference at all.
Everybody accepts it makes no difference at all.
Correct, which is why no point was taken below about the second stage of the Chartbrook test. Because, and again, I'm not making this point to say that the point's excluded or score any points, but that's why the first judgment proceeds on this basis. Submissions weren't necessary in relation to that point, and in a sense, that explains why the judge was allowed to get into this error about the fact that there were two alternative formulations, because that wasn't a point which was addressed. In fact, it was addressed in a footnote, I think, in my skeleton argument, where I said that it's not suggested anywhere that there's more than one way of correcting it, and it's because they form the same mathematical answer. Unfortunately, I stuck it in a footnote, and I don't think my Mr. Justice Fancourt spotted the error.
So there's nothing, if the appeal is unsuccessful, there's nothing wrong with the declaration that the judge made?
No.
Thank you.
Yes.
So, my lord, that is the end of my response.
Thank you.
But to summarise it, the law hasn't changed. It is clear that there is a mistake, using my learned friend's two stages, and it is clear what the mistake is. And the only thing which prevents it from being clear, is the suggestion that there is a further mistake. And in order for my learned friend to succeed on the further mistake, he would then have to
Satisfy the Chartbrook test.
satisfy the child.
Thank you. Thank you very much, Mr. Watkin. Yes, Mr. Dunn.
Lord, one point which was dealt with in the skeleton arguments, but not very much in submissions, is a point that the judge raised about whether or not this provision was designed as a trap. I mention it. It's not. I wouldn't say it's a particularly attractive.
Well,
Nobody suggested that it was.
No.
Absolutely, but the point is this. The question is, how would a reasonable reader understand the lease? And that's to be viewed objectively. So if a reasonable reader might take the view that this was intended as a trap, then the objective reader would see what the commercial purpose was, and it wouldn't be absurd. It would simply be an attempt to pull the wool over someone's eye.
Nobody thinks it was a trap. Nobody suggested it was a trap. This hasn't featured in Mr. Watkins' submissions to this court. So why are you raising it now?
The reason I'm raising it now is because my learned friend submitted in his submissions that there was that to a reasonable person there would be no there would be no justification, no rationale for the provision. That's why he's saying it's absurd. The point I'm making is this: it's for him to establish, not for me to assert. It's for him to establish that a person wouldn't regard this as a trap. They would
You
say
agreed
it's
it.
clearly a
I thought you
mistake.
agreed it wasn't. You both agreed it wasn't a trap.
You're drawing a distinction between what you now agree and what the reasonable objective reader might have
Absolutely,
thought.
absolutely. There's no subjective evidence to say it's a trap, but that's because subjective evidence is inadmissible.
Well, the subjective evidence which was inadmissible was that it wasn't intended as a trap anyway.
Absolutely, but the
But
point
it's a very odd sort of trap because of the break clause. I mean,
no, absolutely. No, except I'm not. I've made the point. Can I pass on?
Yes.
The next point. If we go to trillion, which is the
Tab 16.
tab
30.
no, 30. Is it? No, it isn't. It's beg your pardon, it's tab 12. And I'm not sure if it's quite true to say that the two rent review provisions aren't identical. The one in that lease and this one aren't identical. But it seems to me that the underlying substantive point is exactly the same. Because in both cases, what you had was, you had a provision where you multiply a rental figure by an index and divide it by a base index. And in both cases, there are two ways of correcting the error. One is to change the figure you're adjusting, the other is to change the base index. And the point that Lord Justice Lewison raises is if you've got, and you've already got the point, but the point that Lord Justice Lewison is raising is that if it's an upwards only, since it's, in that case it was an upwards only provision, there would be a material difference in the effect of the lease if you adjusted the base figure as compared with adjusting the rental figure that was going to be updated.
I didn't understand that to be the point. I thought the point was that the formula as written adjusted the initial rent in the reversionary lease, which was 1.2 million, by reference to the increase in the index since 2005.
Yeah.
And if you go back to the rent in 2005, the change that was 980,000.
The point
That's different.
The point that
back to the base figure.
the point that I was arguing in that case was this: you had a 2005 rent
Yes.
that was being updated by references to changes of the RPI since 2000.
Yes.
That was the point. But the reason why Lord Justice Lewison, his third reason for dismissing the appeal, that the reason he gave was one which applies on all fours here, if the provision is upwards only.
Well, I think it's accepted that if the provision is upwards only,
Yeah.
there is more than one possible solution, and they do produce different results. Potentially, they will only do so if there are any negative RPI figures, but if there are negative RPI figures, they do produce different results.
That's right. If I can now take you to paragraph 62 of the first judgment. And again, it's very easy to nitpick a judgment without bearing in mind the fact that this was probably written in quite difficult circumstances, because the judge had heard no oral submissions. It was all done on the basis of skeleton arguments that the counsel had been proposing to speak to in front of the judge. So I say this with no criticism, but when one looks at paragraph 62, what we get from that is the judge seems to think that actually there are some tenants in the market who'd have said, I will take a lease that has this rent review clause because I'm satisfied the break clause gives me protection. And in those circumstances, it is quite difficult to see how one can say that this is an uncommercial contract. Its effect may be one for which one doesn't know why the rent's going up in the way it is, but but the provisions are clear. They are rational in the sense that there is no doubt about how it is you calculate the figure. And if it's indeed the case, as the judge seemed inclined to think in paragraph 62, that tenants might be prepared to take a lease on those terms, it's very difficult to say that no tenant would, which is essentially the test that we're looking at, that no party would enter into a contract on those terms. Nor is it understandable why a landlord would turn down the opportunity to get such a high rent. I accept that the break clause mitigates that. And so I think one needs to look a little bit more carefully at whether this really is as commercially absurd as my learned friend says. If I could now ask you please to go to paragraph 63. Now, maybe I misunderstood something that was said earlier on this afternoon. But the point I'm making, again, it's to repeat, and I apologise for that, but if one's looking at how this is monetised, this is monetised in two stages. The first stage is that the landlord grants the lease. The grant of that lease monetises the landlord's freehold interest by turning the right to possession into a right to receive the rent. The tenant is a company which has shareholders. It was seen that Mr. Feakin was either it was him or was someone who was under his control who held those shares. So the second monetisation would be on the sale of the tenant company. But it is not, you can't say it's in the landlord's interest that the owner of the tenant company should receive a good price on the sale of the tenant company. Because the landlord has received its benefit as monetisation in the grant of the lease. And so it's no explanation to this to say, well, yes, the landlord couldn't possibly have entered into this because it needed the deal to proceed. It didn't need the deal to proceed. It had granted the lease. So far as the landlord was concerned, the deal was complete.
But it does need the deal to proceed because the tenant is an SPV. The tenant has no income. It's not going to be able to pay the rent unless it can build a solar farm. The landlord is not expecting the tenant, while in the same ownership as the landlord, to build a solar farm.
No, that's quite right.
Expecting to sell it to the market. So the landlord does have an interest in there being a purchaser of the tenant SPV, so that somebody actually pays the rent.
But that is not a reason for that doesn't help one interpret the lease.
Well, it does if the result, I mean, the judge's point is, the well-advised landlord would never set something up with this result because it makes it more difficult to sell the tenant. And unless you sell the tenant, how are you ever going to get any money out of it? I mean, just sitting there having granted a lease does not produce a penny of money.
I accept that. Okay, well, if I can now move on to a point that my learned friend made in Manai, which again I'm afraid I didn't quite understand. I thought he was almost suggesting that the chartbook principle isn't confined to mistakes of drafting, but also extends to mistakes in the underlying commercial transaction. I understood.
I know I can re-explain the trend.
No,
I see my learned friend
yes or
turning to
no
me.
will help.
I don't say that the principle is confined, can extend back to the underlying draft.
Thank you.
I say,
Right, good.
what I say is, the question of whether or not there is a prior error is not one which you investigate.
Thank you. Yes, Mr. McDonald?
But as a result of that, if there is an absurdity, you still need to identify for the chartbook principles whether the error was in, should we say, doing the deal, or whether it was in actually encapsulating that deal into putting that into written form. We then move to the question whether or not a mistake was made, whether you can tell that from the terms of the agreement. I've said all I need to on that. In terms of whether whether it's right to split up the question of whether this is upwards only, and whether it's possible to hive that off as a separate issue, I have made my submissions, and the submission is essentially that this is a unitary exercise, that no one who's reading this provision in order to work out what the mistake in relation to the formula is, no one would be able to form a view on that without knowing and forming a view about whether this lease was intended to be upwards only or not. And therefore, this is something where it all has to go into the mix. And if the court is satisfied that there is any, a reasonable reader would have any doubt about whether the underlying purpose was that the rent shouldn't go down, then that would be enough to, I would say, for the appeal to be allowed. So we then turn to the points that my learned friend made about increased. And one always has to be careful about arguments on the lines of, if they meant that they could have said this. But it is notable that they don't talk about changes. If we go back to the provision, it doesn't talk about changes in the cost of living.
Increases.
It's increases in the cost of living. And therefore, I would say that anyone looking at this would think that its purpose was to, while giving is to protect the landlord against inflation, but essentially to provide a ratchet so that the rent didn't go down if the value of money rose. And when we go back to those points that were made in, I think it was paragraph 68 or whatever it was, of the judge's first judgment, it is fair to say, so it's 69 on page 43, it is fair to say that you don't know whether the rent that was originally agreed was a market rent or not. You don't know, you do know that although this makes provision for the rent to go up in line with changes in the value of money, you also know that there's a real possibility that the changes in the value of property may be very different. You also know that the proposed use of the land was as a solar farm, which may well generate significant income as well as electricity, but there was no profit share. And what those tend to suggest is that mere indexation of the initial rent may well be something which could be described as being, in the words of the judge, sorry, I've now lost the wording, but to be a surprising rent review provision. Now, I accept that the difficulty with that is that we don't know what the judge means about non-cumulative indexation. But the learned friend has referred to the idea that indexation is a well-known concept, and one would have thought that most people would understand that indexation is about keeping the value of a thing, making sure it keeps up with the value of money. And therefore, I would have thought that the proper reading of paragraph 69 is the judge is saying that it would be surprising if the rent review clause had the effect of merely making the initial rent payable under this lease keep pace with changes in the value of money. That's it. Unless you have.
What do you want to say about Britvic? Do you want to? Would you like to have a few 7 days? Or perhaps you've read Britvic.
Yeah, the only reason I huff and puff a bit is this, and it's a point that came up this afternoon. We ask ourselves. I've been talking about the relevance and the significance of whether or not there's an absurdity in the drafting, but I do accept that the two Chartbrook tests apply.
Okay.
And in those circumstances, I'd be surprised if there was anything in the judgment that actually had any real bearing on what are the important questions in this case.
All right. Well, can I suggest that you both read Britvic?
Yeah, and if we
It's not very long. I read it on my phone. It's not very long. And let us know by tomorrow whether you do want to. Let me know by tomorrow whether you do want to make any further submissions. And if either of you do, then I will give directions accordingly. But not encouraging you to, but I just thought you ought to be aware of it. Thank you very much, Mr. Dutton. Well, thank you both, and also thanks to Mr. Wilcox and your instructing solicitors for your assistance in this case. The case has been very well prepared and, if I may say so, very well presented. We're going to reserve our judgments. In due course, they will be sent out in draft form in the usual way for typographical correction and minor errors of fact, not obviously an opportunity to re-argue any points. And then in due course, once we've had your comments back, we will arrange for them to be handed down either in the traditional form or under the COVID protocol, depending on what happens on the 21st, I dare say 21st of this month. Insofar as there's a need for any consequential orders, all have an opportunity to deal with those at the same time. Thank you.
Court rise.
Well, I wasn't wrong, was I?